everybody. This is Advocate Lucinda, your empowerment lawyer. Litigation is challenging enough, isn't it? But I always say it's doable. And one of the things that is really critical for the plaintiff to do to make his or her case is to conduct discovery. I always say plaintiff cannot afford not to conduct discovery. And one of the things that the plaintiff must file prior to the time discovery officially begins is what we call initial disclosures. And that's what we are going to talk about today, what the initial disclosures are, when to file them, and how to file them. So let's get started.
So let's recap. What is discovery? Discovery is a process whereby each party requests information and documents from the other side. The process begins and ends at a specific time. The parties will use the data to make and defend their case. There are four discovery tools that the parties usually use to conduct discovery. Request for admissions, you can find that at Federal Rules of Civil Procedure 36, interrogatories, Rule 33, request for production of documents, Rule 34, and depositions, Rule 30. So, initial disclosures. Prior to the time discovery starts, plaintiff and defendant are required to disclose or exchange certain information. Now, here's a caveat. Initial disclosures may not be required in some jurisdictions, so make sure that you check your local rules. So let's talk about what to file. Federal Rules of Civil Procedure 26A1A specifies or requires that the plaintiff provide the name, the address, and telephone number of each individual likely to have discoverable information that the plaintiff may use to support his or her claims or defenses. Now, of course, the defendant has to do the same thing, but of course, being a plaintiff's attorney, I'm usually talking directly to the plaintiff, the pro se. Now, if the individual or individuals are to be used for impeachment purposes, then plaintiff, you are not required to disclose those individuals. Two, a copy or a description and location of all documents, electronically stored information, and tangible papers, for example, things that you have in your possession, custody, or control, and that you may use to support your claims or defenses. Of course, plaintiff, you're going to be supporting your claims. Unless the use would be solely for impeachment. Three, a detailed estimate and computation of each category of damages you claim you are owed. Some time ago, I uploaded a video on computation of damages, and I will put that link up for you to review. Now, here is something that the defendant must disclose that the plaintiff does not have to disclose, basically because the plaintiff would not have an insurance policy. Defendant must identify any insurance policy that may be liable to satisfy all or part of a possible judgment in the action or to indemnify or reimburse for payments made to satisfy the judgment. In other words, if the court rules in the plaintiff's favor, and even sometimes the plaintiff and the defendant will settle the matter. As the court always encourages settlement, the court would want to know if there is an insurance policy and wants to know the specifics in that policy. When to file your disclosures. Federal Rule Civil Procedure 26A1C specifies that the parties send their initial disclosures to the opposing counsel or unrepresented defendant, and that's not likely that a pro se would have an unrepresented defendant, within 14 days after the 26F conference of the parties, unless the court's scheduling order provides a different deadline. Of course, in the 26th conference, both parties will get together and discuss the litigation. They will address things like discovery. When will discovery begin? When will it end? Will there be a possibility that the parties will ask for an extension for discovery? Expert witnesses, those kinds of things are discussed. Dispositive and non-dispositive motions. I'll put it like this. Dispositive motions, there are three. You have your motions for default, you have your motion to dismiss, and your motion for summary judgment. All other motions are what we call non-dispositive motions. And we call them non-dispositive because the judge's ruling on the motion, whatever it is, does not end the case. For example, a default judgment, a motion to dismiss judgment, and a motion for summary judgment ends the case. However, the party can appeal. How to file your initial disclosures. Federal Rule Civil Procedure 26A1C, unless your jurisdictional rules state otherwise, plaintiff do not file your initial disclosures with the court. Send them to opposing counsel or the unrepresented defendant with a certificate of service. You can send them by first class mail or by email if the defendant consents, because a lot of parties agree to exchange information by email. And after both parties have met in the 26th conference, they will later meet with the judge in what we call the 16F conference. There, the judge would hear both parties and will eventually issue a scheduling order based on what the parties discussed and agreed to. And listen, there may be an instance where the plaintiff does not agree with the opposing counsel and vice versa. So plaintiff, you have a right to say to the court, well, I cannot agree with the opposing counsel, but you must have made a good faith effort to address your dispute. Just be prepared to justify your position. The court understands that the parties don't always agree. Please, this is critical. If you fail to provide your initial disclosures, you may not be able to introduce them at trial. The scheduling order is a plan. It is a critical document. It helps the court to know what's going on with the litigation, and it helps the parties to stay on task. So there is no reason, plaintiff, why you should not be able to disclose your initial disclosures. Because remember, failure to do so could also result in sanctions. So make sure you make your disclosures. I am always happy to bring this information to you. And if you haven't already, subscribe. Okay? All righty. We will see you next time on Advocate Lucinda, your empowerment lawyer.